Good afternoon, everyone. Welcome, bienvenidos. For those of you who want to continue in English, please stay put. Las personas que desean escuchar la versión en español, por favor, elegir el idioma oprimiendo el botón en forma de círculo donde dice español en la parte inferior de la pantalla. Gracias. So good afternoon to all of our live attendees today. We are thrilled you're here to engage in this important webinar, a community supporting approach to mandated reporting, training updates and insights on state reform efforts. I'm Dr. Tiffany O'Shaughnessy, and I'm one of the hosts of our webinar today. I use the pronouns she, her, and I'm a white cisgender woman in my early 40s with an undercut/buzzed hair on my left side and chin-length purple pinkish hair on my right side. I'm wearing a black top, and my background is an office with a fiddle leaf bag, a beige couch, and a blue floral painting. I'm a professor and the MFT program coordinator in the Department of Counseling here at San Francisco State. I'm one of the co-investigators for this project, and I'm working alongside the project's primary investigator, Dr. Molly Streer, who's the coordinator of our school counseling program, and my co-investigator, Dr. Julie Cronister, who's our department chair. I would also like to thank our graduate assistant, Jace Perry, who's working hard to stay on top of the technical issues, chat boxes, etc. today. I'd like to acknowledge that SF State's campuses in San Francisco sit on the ancestral homeland of the Ramaytush Ohlone. We further acknowledge that we work on the ancestral lands and waters of many other Indigenous peoples and nations in our fieldwork in the Bay Area and around the world. We also acknowledge the enslaved peoples, primarily of African descent, whose labor built many of the facilities that we gather in, and those of the United States. To move this statement from acknowledgement to action, we encourage you to learn more about the Ohlone people and to lend your time, talent, and other resources and service in whatever ways you deem right and true for you. We're committed to ensuring this webinar is accessible to our audiences. Closed captioning is available in the closed captioning option at the bottom of your Zoom screen. If at any time your access needs are not met or become not met during the webinar, please send a chat directly to a host or co-host. Access is always a work in progress, so we appreciate your comments, feedback, and support. This is our annual training sponsored by our school-based mental health counseling training project, which is fully funded by the Department of Education. The contents are those of the authors and do not necessarily represent the official views of, nor an endorsement by the Department of Education or the US government. A couple of additional things before we begin. If you're interested in receiving continuing education credit for your live attendance today, please pay close attention to the announcements provided in the chat for sign-in and evaluation links. Our thanks to our partner, Counseling and Psychological Services at UC Berkeley, who are approved by the American Psychological Association to sponsor continuing education credits. As a reminder, this is a live recorded Zoom webinar, therefore the audience is not visible and the audience cannot turn on their video or audio. The chat function is available for comments, sharing of resources, or supportive emojis, etc. If you want to ask the presenters a specific question, please post your question in the Q&A function, and we hope Q&A will occur during the last 10 minutes or so of the webinar. So please post your questions in the Q&A as they emerge, and the presenters will answer questions at the end. If we can't get to all of them, we'll give you contact information to reach out directly. And so with all of that, it is with great pleasure that I introduce today's presenters from Safe and Sound, Jenny Pearlman, Clarence Say, and Brianna Green. So Chief Policy Officer Jenny Pearlman has over 30 years of nonprofit and legal experience. She is currently the Chief Policy Officer for Safe and Sound, where she spearheaded a new department to focus on local, state, and federal advocacy and research to improve outcomes for all children and families. Before joining Safe and Sound, Ms. Pearlman consulted with a variety of nonprofits on communication and strategy issues and worked for several years as a lawyer and education advocate with the public interest law firm Public Advocates. She also practiced general civil litigation with the two New York law firms, Kay, Scholler, Hayes & Handler, and Lenkler, Seifert, and Wohl, LLP. Early in her career, Ms. Pearlman taught high school students and trained teachers in Namibia and South Africa. She's a graduate of Georgetown University and with a BS in Foreign Service and Georgetown University Law School cum laude. An active member of the community, Ms. Pearlman has served on the board of several education-related nonprofit organizations. She spends as much time as she can outdoors and continues to seek adventures of all kinds with her 4 children. Second, our additional presenter, Clarence Say, MAT, is an accomplished Asian American educator over a decade of experience spanning direct classroom instruction, curriculum development, community outreach, training, and nonprofit management. His teaching career has taken him from American schools to international classrooms in Thailand with the Peace Corps and in China, enriching his understanding of diverse educational practices and reinforcing his commitment to fostering inclusive learning environments. Clarence joined Safe and Sound in July of 2024, where he leads the Community Education and Partnerships team in building meaningful partnerships that enhance community education and support lifelong learning. In addition to his professional endeavors, he is currently a doctoral candidate focusing his research on perspectives on multicultural children's literature. Clarence's extensive experience and dedication to education make him a vital asset to the Safe and Sound community and a passionate advocate for educational equity, access, and the vision of a future free from child abuse, neglect, and trauma. And last but not least, we have Brianna Green, MPA. She's the Senior Program Manager of Community Education at Safe and Sound. In her current role, she manages the Child Safety Awareness and Keeping Kids Safe program and mandated reporter training. She also assists with curriculum development and scheduling. In her earlier days at Safe and Sound, she spent most of her workday teaching elementary age students how to keep themselves safe, focusing on sexual abuse prevention. Prior to working at Safe and Sound, Brianna was a program director at the YMCA of San Francisco. She oversaw after-school programs and summer enrichment programs. Brianna has made lasting relationships with the families that she worked with while at the YMCA. As you can hear, we have so much knowledge and wisdom in this room today. We have been integrating resources from Safe and Sound into our law and ethics training here at SF State for a few years now. And so we are so excited to be able to learn directly from these folks working to reform our practices. And I'm going to turn it over to our esteemed presenters now.
Thank you so much, Tiffany. It is such an honor to be here with all of you and be in the presence of you who are working directly with children day to day. And we thank you for coming here to learn about some of the reforms that are going on with respect to mandated reporting and how to incorporate those into your practices as you have to think about, how do I best support these families and keep children safe at the same time? So we're going to talk about some reforms that are going on. We're going to talk about how you might implement those into your own practice today. Next slide. Great. These are just our learning objectives, which I briefly just went over. And just to give you another little bit of my background, I had the opportunity to serve on the mandated reporting to community supporting task force at the state level. I have the position representing family resource centers, and I also co-chaired the legal and liability subcommittee. And I am now currently a new member of the new task force that's looking into these reforms in California called the MRAC, or the Mandated Reporting Advisory Committee. So I just want to start and ground us in why we're here. Why does this matter? Why are we thinking about reforming mandated reporting? Clarence, my colleague, will go into a little bit about what is the background. How did these mandated reporting laws come about? And so they're there to keep children safe, right? And so why are we thinking about reporting them? Well, those of you in the field probably know because there are some significant problems with our current structure, our current laws. In the why, I want to focus on two things. One, very briefly, on the impact on people, parents, families, communities, providers that our mandated reporting system has. And then also on some data and statistics that I think will really make it apparent as to why we're working to reform these. Next slide. I'm not going to read this, but here you can see some statements from members of our task force who are people who have lived experience with the mandated reporting system. And when we do this work, it is very essential that we center those with lived experience who have had to deal with the current system and have had to deal with the trauma that the current system creates for families and communities. I think one highlight that I want to point out here is from Shelley, who is a parent, and Shelley was also on the task force. And what really comes through for me there is Shelley talking about how much life and her daughter's life would have been so different if they had gotten the support that they needed from the start rather than being referred to child welfare, and in her case, having her child removed from her care for a period of time. Next slide. I want to start with looking at what are the primary allegations in the child maltreatment allegations in California. In California, the most common allegation is general neglect. In California, it's about 45%. That's what it was in 2023. And that's the case across the nation. It's usually around 45 or 50%. I think most of you are aware, and you'll hear more about how general neglect is defined in California. But general neglect is really a catch-all category that includes many allegations that are better mitigated by supports, many things that are correlated with and actually often conflated with poverty, and also many things that might require a broader set of support for families, such as domestic violence, substance use, or mental health issues with the caregiver. Next slide. You can go one more. So this slide to me is one of the really shocking pieces of data that nobody had been highlighting at the state level or looking. What this slide shows you is the number of child abuse and neglect allegations in California in 2023 by reporter type. So on the left-hand side of the slide are the reporter types, education, law enforcement, and it shows you of those allegations, what percentage of those were substantiated? Where was it determined by child welfare that there was a case of child abuse and neglect that needed an open case where they had to intervene on the family on the family's behalf in some way? You'll see how low that substantiation percentage is for each category of mandated reporters, with 23% being the highest for law enforcement. And that's often because law enforcement is called in where there's an issue of potential violence. They're often called in on domestic violence cases, which aren't per se child abuse, but that's where they often get involved. For education, the field that many or most of you are in, the substantiation rate is only about 4%. And so that means there are 96% of calls that go to child welfare from education that aren't substantiated. And I know you all know there's a variety of reasons why those are not substantiated, but this data certainly shows us there is a significant amount of overreporting, and there are multiple reasons for that, but that we need to make some change. We need to address this situation. I mean, some of my colleagues have said, in what other instance is there an 89% failure rate and we don't do anything about it? So we're hoping that we can move this work forward to make those changes. Next slide. So not only is there clear evidence of significant overreporting, but here on this slide, you see that the data shows significant disproportionate impact by race. 1 in 2, or 50%, of Black and Native American children in California and pretty much throughout the country experience a child welfare investigation by the time they're 18. And you see on the right-hand side of the slide that that disproportionality continues as we move through the child welfare system. So here for Black children who represent only 5% of the population in California, there's a 14% investigation rate. And there's even more shocking and striking is a 21% removal rate for Black children, a separation from their families. Next slide, please. So in addition to the impact on families, on children, on communities from having children torn apart from their families, having families destroyed, and the long-term trauma that that can cause for those individuals and those individual families and the communities, and the generational trauma that that can cause. This current system also has some other really significant impacts. So one, This first one, it creates a chilling effect for families, right? If you're afraid that if you ask for the help that you might need, that there's going to be a call to child welfare, you're not going to go to organizations. You're not going to talk about the needs that you might have. You're not going to talk about the help that you might need in supporting your child or your family. There's that continued, I mentioned this, trauma and stigma that is long lasting for families. So even if the investigation doesn't go forward, there is still that stigma in the community, that stigma in the school, that trauma that the family and the child have experienced. And then finally, for the child protection system itself, having so many calls that are unsubstantiated overburdens that system. And so that system is unable to respond when it's a more serious situation where there is a true safety threat to a child. And I'm sure all of you have experienced, or your colleagues have experienced, calling child welfare because of your concern for a child and them not getting anybody, not having a call back for many, many times, for many, many hours or days, even sometimes, not knowing the result of your call. And that's because the system is really overburdened and it just continues to get worse. Most child welfare departments in counties across the state have, they're experiencing a severe loss of personnel. So I will now turn it over to Clarence to go into some of the history of the mandated reporting laws.
Thank you, Jenny. So now that we've heard a little bit about kind of the data on the results of mandated reporting kind of over the years, we want to think about why we have mandated reporting. What's kind of a history of mandated reporting in the US? Of course, it's not the history, but I'm going to give you a brief history of mandated reporting in the US. And if you think about the modern era of mandated reporting, it can be traced back to Dr. Kemp, who in 1962 published the paper, The Battered Child Syndrome, which documented patterns of intentional injury to children and criticized medical professionals of the time for ignoring or misdiagnosing abuse. So Kemp's work kind of sparked some national outrage and advocacy and kind of led to calls for action by the media and various groups across the country. And so that kind of led to, in 1963, the first states to start enacting mandatory reporting laws requiring certain individuals, often the case they were physicians, to report suspected physical abuse. In 1967, all 50 states had adopted similar laws through early statuses focused narrowly on severe physical harm by caregivers and applied only to medical professionals. The Child Abuse Prevention and Treatment Act, or CAPTA, in 1974 was enacted, requiring states to pass their own mandatory reporting provisions. So while CAPTA did not mandate national reporting standards, it required states to implement their own reporting systems to qualify for federal funding. So this really incentivized states to expand definitions of abuse to include neglect, sexual abuse, and emotional harm, and broaden the scope of mandated reporters. So that kind of takes us now to 1980 in California. So California then enacted the Child Abuse and Neglect Reporting Act, or CANRA, in response to CAPTA. And that's something that we'll kind of go more into depth in Brianna's section. But since its enactment in 1980, they've increased kind of the number of individuals that are required or who are mandated reporter, as well as who are required to have mandated reporter trainings. So for example, in 2014, Assembly Bill 1432 required training for teachers and school personnel. In 2015, AB 1207 required training for daycare providers and employees. 2020 required training for businesses that hire teens, and then in 2021 requiring training for all youth service organizations. So you can see there's been an expansion since then in terms of who is a mandated reporter as well as who is required to receive training on mandated reporting law. So when we think about intent and purpose of CANRA, specifically in the Penal Code, it says that the intent and purpose of this article is to prevent children from abuse and neglect. In any investigation of suspected child abuse or neglect, all persons participating in the investigation of the case shall consider the needs of the child victim and do whatever is necessary to prevent psychological harm to the child victim. So when we're thinking about the intent and purpose, it really is to protect children and their families. That's the intent and purpose. But then now thinking about the unintended consequences of mandated reporting, which is something that we're going to focus on, I think, especially towards the end of this training, is thinking about how structural racism and system biases have distorted implementation. So kind of circling back to what Jenny was talking about, thinking about ways in which it has caused harm to families and children, particularly those BIPOC children and their families in the United States, through kind of overreporting, which is a really big issue in terms of what we're seeing in the data, as well as surveillance, trauma and family separation, economic and legal penalties, as well as bias in decision-making, which is something that we're going to circle back to towards the end of the training. But these are all really important kind of components to think about, and how these unintended consequences have disproportionately affected or impacted low-income BIPOC children and their families in the United States. So some recent legislative reforms that have occurred that we want to kind of keep track of as we move towards kind of reforming mandated reporting law, signed in 2022. It was Assembly Bill 2274, which limits the filing for a failure to report an incident of known or reasonably suspected child abuse or severe neglect to within 1 year of discovery of the offense and no later than 4 years after the commission of the offense. And then in September 26th of the same year, AB 2085, which is a really important assembly bill that we'll also come back to, modified the definition of reportable general neglect by clarifying that economic disadvantage is not general neglect and that a child must be at substantial risk of suffering serious physical harm or illness. So this really thinks about kind of when we're reporting on child abuse and neglect, what is general neglect? And making sure that we are not conflating neglect or severe neglect with economic disadvantage, and making sure that we are clarifying the meaning of what we mean when we're saying substantial risk, right, of suffering serious physical harm or illness. And then Senate Bill 1085 specified that poverty alone is not a reason for the court to take jurisdiction and for a family to enter the child welfare system. In October 8th of 2023, Assembly Bill 391 requires an agency receiving a report from a non-mandated reporter to ask the reporter to provide specified information, including their name, telephone number, and the information that gave rise to the knowledge or reasonable suspicion of child abuse or neglect. So this Assembly Bill in particular is, so prior to this Assembly Bill, if you are a non-mandated reporter, you would be able to make a call anonymously and not have to provide your name or any information. So this Assembly Bill requires that that information be requested. And if it's refused, if the reporter refuses to provide their name or telephone number, then the agency taking the call must kind of make an effort to determine the basis for that refusal and advise the reporter that the identifying information will remain confidential. So this is kind of moving away from anonymity in reporting, but still ensuring confidentiality, which I think is important. And part of what we're doing as an organization at Safe and Sound is also trying to keep track of what kind of are the new legislative reforms that continually are moving towards kind of moving from mandated reporting to community supporting and being able to actually support families and children. Yeah, now I'll move on to pass on to Brianna, who will take us into who is a mandated reporter as well as more deeper into CANRA. Thank you.
Awesome. Thank you, Clarence. So who is a mandated reporter? A mandated reporter is anyone who is working with children. There are 49 categories of people who are mandated reporters, and some of those people are educators, janitors in schools, social workers, also technicians like Comcast and AT&T folks that come inside of your home. Volunteers are not considered mandated reporters unless they are unless they work or unless they volunteer for CASA, court appointed special advocates. Next slide. Okay, so we have legal responsibilities as mandated reporters. So a mandated reporter, if they suspect child abuse, then they should call their local agency. In San Francisco is Family and Children Services. They will send in a report, and we'll talk about that a little bit later. And they will make the phone call, then send in a report. If a mandated reporter fails to report suspected abuse, then they may receive a fine and or jail time. Next slide, please. We're now going to get into some definitions of abuse. We're going to talk about child abuse and neglect. So we are going to go over definitions of physical abuse, emotional abuse, sexual abuse, and general neglect and severe neglect. Next slide, please. All of these definitions are taken from a penal code, from California's penal code. And so it includes physical injury of death inflicted by other than accidental means upon a child by another person, sexual abuse, neglect. And we'll move on to the next slide. When I'm going to go to the next slide, Clarence. Thank you. I also want you all to know that I will go over some indicators. I'm not going to go over all of the indicators of the abuse, but I will try to hit some of them. So our first definition is sexual abuse. And sexual abuse means sexual assault or exploitation onto a child. So that can be rape, it can be incest, it can be sexual penetration, it can be touching the genitals or the intimate body parts of a child. Sexual abuse can be touching or non-touching acts. So touching acts, actually touching the child's genitals or some part of their body. Non-touching acts would be watching pornography in front of a child or making a child masturbate in front of you or watching a child masturbate. Some indicators of sexual abuse is a child's disclosure. If a child discloses to you that they have been sexually abused, we believe them, and then we contact the appropriate people. In San Francisco, that'd be Family and Children Services. If a child has unexplained STDs, if a child if a child displays sexual development that is not aligned with their age group, those are just some examples of sexual abuse. Next slide, please. We're going to talk about CSEC. So CSEC, also known as commercial sexual exploitation of children, it refers to crimes involving the sexual abuse or exploitation of children for financial gain. So that may look like child sex trafficking, it may look like child pornography or child sex tourism. So some indicators of CSEC, children that may experience CSEC are they may have a tattoo on their body that is from from the organization that is working with them. It could be a gang. It could be their perpetrator's name on them. They can also be picked up in sex trafficking areas or sex work areas. They may also be truant from school, and they may have unexplained items. Like, so a child that typically does not have a designer bag, out of the blue has a designer bag, has items that you know that their family cannot provide for them. Next slide, please. We're going to go over neglect now. We'll first talk about neglect on this side, then the next slide we will talk about general neglect. So severe neglect means the negligent failure of a person having the care of custody of a child to protect the child from severe malnutrition or medically diagnosed non-organic failure to thrive. It also means those situations of neglect where any person having the care of custody of a child willfully causes or permits the person or health of the child to be placed in a situation such that that person or the health is endangered. Next slide, please. So general neglect is a negligent failure of a person having the care or custody of the child, and they're not providing adequate food, clothing, medical care, or supervision, or no physical injury to the child has occurred. We do want to let you all know and to enforce that a parent or caregiver's lack of resources is not should not be a reason that we call Family and Children Services on a family. So just because a parent is lacking resources does not mean that they are neglecting the child. As we all know, especially in San Francisco, it's expensive to live, it's expensive to take care of a child, and if a parent or caregiver does not have the means, it does not necessarily mean that they are neglecting their child. On the next few slides, we're going to be talking about AB 2085. Sorry, no, we're going to talk about indicators first. So some indicators of general neglect are lack of basic needs, a significant lack of basic needs, supervision, so that may be like leaving a child home alone without the proper resources, medical care, educational needs are not being met, emotional support, and unsafe living conditions. Here we're going to talk about AB 2085. So a few years ago, the bill came into place to where it stated in the definition of general neglect that includes circumstances where the child is at substantial risk of suffering serious physical harm or illness, and would provide that general neglect does not include a parent's economic disadvantage. And AB 2085 only changes general neglect. It does not change severe neglect, sexual abuse, or physical abuse, or emotional abuse. Thank you, Clarence. All right, moving along. I want to talk a little bit about physical abuse. And so physical abuse is the willful harming or injury of a child, or the endangering of the person or health of a child. Unlawful corporal punishment or injury where any person willfully inflicts upon any child any cruel or inhumane corporal punishment or injury resulting in traumatic conditions. So some indicators of physical abuse may be bruising, maybe burns, maybe whelps, maybe head injuries, and sometimes bite marks. Next slide, please. Emotional abuse is one of the harder abuses to determine. So when emergency response social workers are determining if there is abuse with emotional abuse, they will get advice from mental health professionals. So emotional abuse is when we have the knowledge of or reasonable suspects that a child is suffering emotional damage or is at a substantial risk of suffering serious emotional damage, which may include severe anxiety, depression, or withdrawal. Some indicators of emotional abuse may be withdrawal. It may be self-harming actions. It may also be wanting to please certain adults. We see this a lot with younger children where they really want to please their teacher. And also regression in eating and also bedwetting. Next slide, please. So now we're just going to briefly talk about domestic violence, also known as DV. And so refers to abuse committed against specific individuals. And so it could be between partners, so romantic relationships, spouse or former spouse. It could be people that live together, dating or engagement relationships, someone that has a child with the perpetrator, or are related by blood or marriage within the second degree. Next, we're going to talk about coercive control. So in 2020, the State Family Code established the coercive control constitute abuse under the definition in the state's DV Prevention Act. So coercive control is a form of domestic violence in which an abuser uses a pattern of abusive behavior to dominate their partner and limit their partner's freedom. So that may be keeping the partner away from their family and friends or any social connections. It may be taking their money from them or telling them how to spend their money. It can also be depriving them of their basic needs and also humiliating or being verbally abusive to the victim. Next slide, please. If a child discloses that they have been abused, or if they don't disclose, but you suspect that there has been abuse, we want to make sure that we discuss the matter with them privately. And so that may be one-on-one with the child. For some of us, we may want to have another colleague in the room with us. So if a child discloses to me, I usually have another person in the room with me. And most of the time it's a social worker from one of the schools that I'm working at. And that's to make sure that the child feels comfortable when they are telling me the story of what happened. You want to get on the child's level. You want to ask them open-ended questions, starting with who, what, where, when, why. And excuse me, when talking about where, you want to know where on their body, but also where as far as jurisdiction, so that you know what hotline you want to call. So am I calling, or county, sorry, what county you want to call. So am I calling San Francisco, or am I calling Alameda County? You want the children to tell the story in their own words. Okay, so we don't want to force feed them anything. We want to remind them that they did the right thing by telling us. Thank you for telling me. You're keeping yourself safe by telling me. Then you want to let them know your next steps. Depending on the child's age can depend on what you tell them. So for my kindergartners, I may say, thanks for telling me. So now what I'm going to do is I'm going to call some other adults to figure out how I can help keep you safe. And again, reminding the child that it's never their fault that someone has broken a safety rule with them. It's the person's fault who broke the safety rule. Next slide, please. Okay. So after you've spoken with a child, you need to make a report, and you suspect abuse, then you need to make a report as soon as possible. And when I say as soon as possible, you may not be able to do it right after you've spoken with the child. There may be a little bit of a time lapse. It shouldn't be too long, like hours, but it may be 10, 15 minutes before you can actually get to a phone call and call. And so you want to call Family and Children Services. The number is listed here. And then you want to follow up with a written report, which is called the SCARS report, SCARS form. And we'll talk about that next on the next slide. Thank you, Clarence. So once you call Family and Children Services, you then need to, and they take your information, you then need to send in this form here, and you can fax it, mail it, or email it. I personally like to print the form and then write out the information before I call, because when the emergency response hotline worker is taking your call, they're going to ask you in the order of the form here. If ever Family and Children Services has more questions for you, like they may say, can you go back and ask the child this? Please do so, and then get back to them after. Next slide, please. So when you are calling Family and Children Services, they are entering the information, which in a tool, in a protocol called the structured decision-making tool. And so they are looking for histories, they are looking for any other information that may be on the child or the family or even the perpetrator. And so the hotline worker will gather all that information. Then emergency response social worker will then follow up with the families if need be. So they are talking to the child, they're talking to parents, caregivers, or any witnesses that were around. And sometimes witnesses may be a mandated reporter or someone else in the school or community. And then they will assess to see if the child, of what actions should take. Next slide, please. And so these are the assessment results. So it's unfounded. Maybe the report is determined that's not true, or there's not enough evidence. Inconclusive, there's not enough information to know either way. Substantiated is there's credible information, and there is evidence. Social workers, the emergency response social workers, yes, they will determine how soon they need to come out. If it's an emergency, like maybe evidence may be lost, they will come out within 2 to 24 hours. If the child is not in imminent danger and they still need to come out and do an investigation, they may come out in 2 to 10 days. Next slide, which I believe is a break.
Yeah, so I think that's before moving to the next section. I think kind of prefacing all this information that was shared. I think it was shared earlier, but Brianna does all of our mandated reporter trainings in San Francisco. So in kind of creating this training, we really wanted to also present some of the information that we also present in that mandated reporter training. And part of our goal with this is to make sure that we are aligning what is in the training kind of directly with what is being stated in Canva, right? Which I think is really important, being able to access and know that you can yourself look into Canva and see what is written in Canva to be able to know what is defined in California law with regard to mandated reporting. And I think also being able to be informed about not only what is written in law, but as well as the process with which what are the indicators for identifying kind of child abuse and neglect, what it is, what it isn't, as well as ways in which to file a report and the process of reporting, I think is really important information for us to not only do one training on, but consistently be aware of and updated on a regular basis, which we think is really important. So we appreciate you with regard to, sharing a lot of that information here. But I think next we do have a 10-minute break before we move into the next section. So let's jump into that.
And
Yeah.
Is it a 10-minute break or a 5-minute break?
We just need 5 minutes.
5 minutes. Okay, we'll take a 5-minute break.
So that's back at 2:48, everyone. Thank you.
Okay. So let's start with what is implicit bias? So implicit bias refers to thoughts, attitudes, or stereotypes shaped by experience and based on learned associations between particular qualities and social categories. So that includes race, age, gender. These implicit biases can then influence our perceptions and behaviors, even if we ourselves kind of are unaware that those biases exist. So the roots of implicit bias lie kind of in how we're wired. So in the human tendency to organize the world kind of into categories. It's kind of a cognitive shortcut known as social categorization. So it's a process by which we group individuals based on social information. So kind of the big 3 social categories, you could say, are sex, race, and age. We also tend to group people through other factors. So that can include like social status, occupation, sexual orientation, religion, politics, even just appearances. So social categorization helps the human brain process information quickly, but this process of broad generalization can also lead to stereotyping. So your environment, your upbringing, social media influences, and social circles can subtly and continuously shape these biases. So when we're thinking about mandated reporting as well as reporting, we want to think about how implicit bias can often come into play when reporting. And we want to remember that these are things that we're often not consciously aware of, right? So how is it that we can become more consciously aware of those biases or implicit biases before we report? So an example, a key example here is thinking about how equating poverty with neglect and race-based reporting, right? So those are two kind of areas that we're seeing in the data, right? Where there is kind of large proportions of general neglect being reported, but not substantiated. And same when thinking about disproportionality with regard to reporting numbers on individuals of color, and how those numbers don't are very much disproportionate when you're thinking about Black children versus Asian children versus white children versus Hispanic children, which I think is really important to think about. Another thing to consider when we're thinking about the impact on families, is also trauma, right? So how reporting can be a traumatic experience for a lot of families and children, right? So when we're thinking about defining trauma, the Substance Abuse and Mental Health Services Administration, or SAM, HSA, define trauma as individual trauma can result from an event, series of events, or sets of circumstances that are experienced by an individual as physically or emotionally harmful or threatening, and that can have lasting adverse effects on the individual's functioning and physical, social, emotional, or spiritual well-being. So we really want to think about how high rates of unsubstantiated reports lead to significant unnecessary harm and trauma for children and families. And our understanding now of trauma is that it can have long-standing effects on children and individuals in those families, right? Where unnecessary investigations can cause confusion, fear, anxiety. And not only are those in the moment, but also further down the line, how the stress from that trauma can cause also like physical harm to those individuals. And that can come in the form of adverse health effects later down the line. So when we're thinking about the impact on families, Jenny kind of talked about this when we're looking at the mandated reporting to community supporting task force report. Over the last decade, the number of children in California reported to Child Protective Services, or in the case of San Francisco Family and Children's Services, has ranged between 400,000 to 500,000. Yet the number of substantiated allegations has consistently been less than 15%, and currently is closer to 11%. So this is thinking about substantiated. So this is after the report, and they've been investigated and looking at unsubstantiated cases. Mandated reporting laws have expanded, widening the gap between allegations and substantiations without addressing critical concerns, including the role of racism and bias in their enforcement. And kind of that question of thinking about under what other circumstances would anyone accept a nearly 90% failure rate when thinking about these reports. So what can we do to kind of combat those negative effects of reporting and kind of those numbers in terms of when we're thinking about over-reporting and the disproportionality? And what we're kind of moving towards now are thinking about ways in which we can implement more decision-making tools and allowing those to be able to be available for mandated reporters, and thinking about the critical thinking aspect as well as kind of taking a pause before reporting. So a quote I really like is from Dr. James Metz. And Dr. James Metz is a pediatric hospitalist. He's the head of the child protection team at the University of Vermont Children's Hospital. And he says that reporting is not benign. And that's something that I often think about, like reporting is not benign. And thinking not that, I think previously the sentiment was always like, when in doubt, report, right? And we really want to move away from that and thinking about how reporting itself can cause harm, right? And even though you may feel like you are making the report and then stepping away and letting the system do its thing. That is really not often the case, where your report is actually directly impacting that
Can't hear
family or
you.
that child. Oh, sorry. Can you hear me now?
We can hear you. Yeah.
Oh, you can hear me? Okay. Okay. So where you're thinking about how your report or the report that's made can really directly impact that child or family, and kind of how it has, an effect, a domino effect in terms of like how that family is able to thrive, right? Which is ultimately the goal, right? We want to be able to allow children and families to grow and thrive. So in kind of conversation, I think he kind of points out some interesting elements with regard to reporting. So thinking about how it's important to take a pause, or what he calls a timeout, or an intentional moment, to ensure we know why we're reporting, we know the reasons for it, and that we're reporting at the right time and on the right person, right? So often, like what I like to think about is, the ladder of inference, right? When we're thinking about here, we're not jumping to conclusions and we're not jumping to actions based off of just what we're seeing and the selected data that we're kind of just pulling from an incident that we may be observing, right? So it's important really to be reflexive, right? When we are making a report, we are taking an intentional moment to ensure that we're making a real report that is needed, right? So part of that, what I'm going to do here is I'm going to take us through some tools that different states have been implementing, or different counties have been implementing, and then kind of circle back around to kind of recommendations from the task force that Jenny will take us through. So this one is pulled from New York State's Office of Children and Family Services. And this is one of their main recommendations, is to really think about how are we assessing for bias, right? And really considering the question of, would you make the same decision to call if any of the following of these categories were different, like the child or family's race, ethnicity, gender identity, kind of going through that list one by one, and thinking like really carefully with regard to what may be some of those implicit biases that you're carrying into what you are observing, or what story you may be creating based off of your lens, right? The way in which you are viewing the situation based off of where you're coming from, your background, and your understanding of what may be happening. They also really recommend critical thinking, which I think is really, really important. I think we use critical thinking in so many other domains of life that it also needs to be brought into the domain of mandated reporting, right? We're not just making a report because we feel like it or think like we should in the moment, but we really have to critically think about what are we reporting? Why are we reporting, right? So the best tools we have to combat it really is thinking about what are we required to do prior to making that report. So here they kind of take us through some guidelines, which I think very much is taking us through that ladder of inference, right? So kind of identifying what specifically concerns you about this situation. When you're telling that story in your head of what's going on, what are you observing, and what are the gaps that you're filling in, right? Are you gathering adequate information about the current situation? Are you analyzing that information to separate facts from assumptions? Are you recognizing the possibility of bias in your personal opinions, right? You have to acknowledge that there is a possibility that you are bringing some bias into this decision-making process, right? And actually, it's pretty much guaranteed that you're going to bring in some potential bias. So what is that bias? How can you identify that? Ensuring that you're temporarily suspending judgment, right? Developing multiple hypotheses that could explain the situation. And then after you've gone through this whole critical thinking process, determining whether or not you are legally required to make a call or make a report. Or if maybe an alternative option is better, right? Because if you think back to what is the intent of mandated reporting, it really is to protect children from child abuse and to be able to support families. So what is going to do that best, right? Ultimately is what is important. And I think if that is really your goal, you need to take yourself through that critical thinking process to make sure that you are reaching the goal that you are saying that you would like to reach. Oh, sorry. So this is the critical thinking and reporting right here. And we'll also provide these slides and resources for you to be able to take a look at. So now kind of moving to the Wisconsin Department of Public Instruction, they kind of synthesize the critical thinking into a 4-step process, right? And they talk about in their 4-step process, the first one being gather information. The second being engaging in critical thinking, which kind of ties back to what New York State was saying. Third is really considering the impact of bias. And the fourth is to report and or support a family with resources, right? So you can do one, you can do both, right? You got to think about what is most needed by the individual that you are working with or you're observing or you're trying to support. So when warranted, a report should help initiate a possible collaboration to broaden the child support system. Okay, and now kind of bringing it back to California, Los Angeles County, they have their mandated supporting initiative. And so this is pulled actually directly from their initiative. And one important way in which they're trying to address the overreporting and the challenges with regard to the negative impacts that mandated reporting has had on children and families is to think about really how the disproportionate number of general neglect reports, how can we address that? How can we make sure that reports are not being made just because, you know, for example, a kid comes to school and he's been wearing the same shirt for a few days and it's a little bit dirty. Is that a cause to make a report? Or it maybe somebody they're working in a daycare and one of the children is maybe doesn't smell so great and doesn't seem to have taken a shower in a few days. Is that a reason to report, right? Thinking about what is actually something that is putting that child at substantial risk of harm, and what are other ways in which we can intervene to be able to support that child or support that family before making a report. So they've created here a general neglect decision tree, which I think is really helpful. And when we think about even the way in which here in San Francisco, Family and Child Services, they go through that decision-making, right, process, they also use kind of these decision-making trees, right? Thinking about if yes or no, kind of what direction do you want to kind of move in? So if you start here at the top, and I think this is the largest. Okay, so here, if you take a look at the top, it's thinking about at least the way that they take us through it in terms of the decision-making process is thinking about first clarifying the concern and how AB 2085 may apply. So if you recall, AB 25 is is change the definition of general neglect to not include a child's or a parent's economic advantage, and includes kind of this, that it needs to put this child at substantial risk of suffering serious physical harm or illness, right? So clarifying the concern and how AB 2085 may apply. So when determining whether a situation mandates a report of suspected general neglect, considering kind of these different questions, right? As you're kind of going through this decision-making tree. So do you know or reasonably suspect that the child has been a subject to or is in danger of physical abuse, sexual abuse, emotional abuse, or severe neglect? Yes or no? And then kind of moving down that general neglect decision-making tree. The second piece of instruction that they kind of give here, or guidance, is to consider your point of view, which is very much similar to kind of Wisconsin as well as New York is recommending, kind of thinking, what questions can I ask myself to ensure that I am thinking clearly about this? How am I addressing any potential biases? How am I separating facts from assumptions? The third step here, they say, is to consult whenever reasonably possible. So this is a recommendation, right? They're recommending that you do not make a decision in a silo. You're not making a decision just in your head. in the quiet space of your own room, right? You are bringing it out into the open, and you are having a conversation about it with somebody that you trust, or somebody that will be able to give you, who has a strong understanding of this landscape, right? And really asking yourself the question, would discussing the situation with somebody else help me make a more informed reporting decision? If yes, then of course, definitely consult with somebody, right? Oftentimes when you think about, when I think about some of the worst decisions that I've made, they were made without asking somebody's thoughts or opinions on it, right? And I'm just kind of making it on my own. So I think it's important to be able to feel comfortable that you can consult somebody that you trust. And then would it help you check for any biases when you're kind of telling the story or seeing or talking about what you observed, right? And of course, this is a recommendation because according to Canada, according to mandated reporting law, we cannot prevent anybody from making a report. So if you have somebody that's coming to you asking your advice or consulting you with regard to this report, as a supervisor, you cannot, and it's actually legally not allowed for you to say, no, you cannot make a report. I forbid you from making a report, right? That individual has the right and will always have the right to make the report even without consulting you. So I think that's an important distinction to make, where every mandated reporter still has the right to report. But I think here we're kind of recommending that we still have conversations about it so that they can make an informed report. The fourth recommendation here they put in terms of steps is to complete the general neglect decision-making tree, right? And I have this even just printed out next to my desk, because I think part of the practice of a decision-making tree is taking you through those steps intentionally, right? So the first few times, maybe it's a little bit slow, maybe it's a little bit cumbersome, and maybe it doesn't feel natural, right, to go through these decision-making steps. But I think the purpose of it is it's kind of like it's showing you that decision-making process visually, right? The decision-making process that you're already having in your brain, and now you're structuring it away so that you are intentionally making these decisions while you are considering the situation, right? And this is a part of the practice of it, right? So part of this is, as you kind of go through this decision-making tree, you're considering all these questions, taking yourself through this process, and eventually it will become more internalized and will become something that comes more naturally to you when you need to make that decision further down the line. So I think this is a really important resource to have, and I think it's really important. I think even in terms of next steps, I think this is something that is being considered with regard to ways in which we can visualize for people how we're making that decision-making process prior to making a report, right? Which I think is very valuable. So yeah, that's my section. I'll pass it back to Jenny.
Thank you, Clarence. And I do see one question in the chat from Shelley that I wanted to respond to. She asking about a slide on the statistics with the disproportionality statistics. And yes, that slide is showing that 50% of Black and Native American children in California experience some type of child welfare involvement before they turn 18, by the time they're 18. And that may be that is evaluated out, doesn't go further, or it may go all the way through to a removal. And as we've been talking about, that even if that report is not investigated or substantiated, that still has a significant impact on that child, that family, and the community in which that child lives, and on the reporter. It is hard to make a mandated report. We recognize that. So, and then that slide also did show that a quarter of white children in California also will experience child welfare involvement. So it shows how large our net is in California, and it's pretty similar throughout the country in terms of bringing that child welfare involvement into the lives of our families. So with that said, and all the other information you've received, there's been this building movement of we need to change the system. Something is going on here. And we understand now, for multiple reasons, and the underlying systemic racism that Clarence mentioned, that system was built on that. And we need to start taking steps to change that system. So California has been a leader in starting to think about, we've heard that other states are, as Clarence pointed out, there are some other states that are doing some work too. New York, actually, surprisingly, Texas, Montana, that Washington State, they're also doing work to reform their mandated reporting systems. And we in California, this really kind of culmination of many factors, obviously people with lived experience talking up, and finally the systems leaders, the policymakers listening to them. And Safe and Sound wrote an issue brief in 2022. And in 2023, the Child Welfare Council, which is a partner to the Child Welfare Department at the state level, heard from all these groups, heard recommendations from one of their subcommittees, and approved the creation of a task force that we've been referring to really think about how to transform our child welfare or our mandate reporting system from mandate reporting to something that is more about community supporting with those decision trees, with really thinking about the bias before making that report and thinking how you can connect the family to resources. If you can support the family from the start, is that really the intervention that they need? It's not necessarily having that punitive intervention by being referred to child welfare. So I'll talk very briefly about the composition, how the task force was made up, and then go into the recommendations that have come out of a over a year-long process. So the group that worked on pulling together this task force after it was approved by the Child Welfare Council had a very extensive application process. The reason being they wanted a very diverse group to be part of the task force to hear the diverse voices. So there were over 250 applications from a variety of different professions, people with lived experience. And from that, 32 task force members were chosen and 78 subcommittee members. The task force launched in September 2023. And key to the composition of this task force was ensuring that there was a group of experts with lived experience and with proximity to the mandated reporting system or child protective services. So that's whether that was a direct experience or experience as a mandated reporter or experience in trying to change the mandated reporting system or something about child welfare. You'll see here from this graph, just some examples. I'll shout out our 88% of the task force members worked or had personal experience with the child welfare system. 28% had lived experience as either youth who had gone through the system or parents or caregivers. And then 59% of the task force members were mandated reporters. Also, there was diversity of backgrounds from different sectors. 7 different sectors were represented on the task force, and also 11 different counties, both small, large counties, and urban and rural counties. And the subcommittees were also similarly diverse. Next slide, please. So after creating the task force came together, and one of our big jobs was to figure out, what was our guiding star, what were our values, and how are we going to bring this diverse group of people to come up with a set of recommendations. So the guiding star of the task force really was to change that frame rather than, oh, we need to jump in and protect children, similar to report, to change that frame to how can we safely keep families together with the resources they need to thrive. So that was our guiding star. And with that, we created a set of values, strategic priorities, And after many months of very challenging conversations and very diverse perspectives, in my subcommittee, we had several people who had worked for child welfare. We had people who had lived experience. We had therapists. We had people from education, and we had advocates. And so it was hard to come up with recommendations, but we did. Recommendations were issued in June of 2024, and then a report was released in September 2024. And that was unanimously approved by the voting members of the Child Welfare Council. That report there's a link to it in here, and so you can access that. You can also access on the Child Welfare Council's website all the materials related to the task force. They're all public on that website. So I'm going to go into the recommendations, which really fall into what we call sort of 5 levers of change. So we grouped them by what are the changes, what are the actions we're going to need to take to implement these recommendations. The first is related to data and accountability. The second is related to legislative and policy changes. The third to changes regarded the mandated reporter training that is some of us receive from our employers, some of us receive through the online training through the state, and some of you are here receiving it today. Then we also, the fourth was building a community pathway, which is really creating the ability for mandated reporters to connect families to the resources they need to thrive so that those families can get the support they need rather than trying to get that support or not getting that support at all and have punitive action taken through against their family through the child welfare system. And then finally, a narrative change. So this first one you see here, this is the first set of recommendations under data and accountability. The first one is the one I already mentioned, which is really to establish another body at the state level, but to make sure that we have a body that has the authority and the support of the entire state to make these changes, and that it will go on for many, many years until these reforms happen. And so we have with success established a mandated reporting advisory committee called MRAC. And we are starting that up in this month, in a week, I think, is our first meeting. That has the support of the California Department of Social Services, as well as the California Department of Health and Human Services. And they will have members on that committee. And there are also many community members representing mandated reporters, representing different disciplines, as well as people with lived experience. And then another key piece of all of this, you saw how powerful some of that data is that we're finally paying attention to with respect to how many reports are made, how many reports are substantiated, and the severe disproportionality of those reports on Black and Brown communities. But we also need to understand more, what does the data mean, particularly around things like neglect? And so because general neglect is such a big catch-all category, we need to understand if we're going to change that, if we're maybe going to remove neglect from a required reporting aspect, what are those types of cases? What are the types of supports that families would need when they fall into this general neglect category? Also, what we're talking about today, we want to continue to ensure those changes that happen with AB 2085, which changed the definition of neglect and heightened that standard within reporting neglect, general neglect. And I know that many, I go do these trainings all the time. We ask people to raise their hand or to put in the chat whether they had heard about these changes to AB 2085. And we've learned that, many, many people still haven't heard about the change to neglect to really try to disentangle general neglect from poverty. So we want to make sure that information gets out there and that we continue to work with different counties on how are they actually going to implement this? What does it mean? Can they all use that decision tree that Clarence talked about? And that's, you know, to move towards a goal of potentially removing general neglect from a reporting requirement. Next slide. The next lever of change area is on policy. And one of the first ones is we had a lot of discussion about looking at those many, many categories of mandated reporters in the Canada statute. Brianna talked about those many categories. We're up to 49 in California. And there was a period where we just kept adding, you know, the case would come in where there was a terrible situation and we pull in film developers because there was a case where there was, you know, child exploitation in the pictures and a film developer discovered them. So then we create that and make all film developers mandated reporters. So we wanted to look at that. What we decided the recommendation would be around that was to do some type of pilot. LA has started some of this work to see if narrowing the categories of mandated reporters would negatively impact child safety. So want to keep following that, do a pilot, gather the data from that. Other recommendation here that I've mentioned is potentially, there was a bill last year, the bill failed, but to support removing that really broad category of general neglect from a required reporting element in the statute entirely. And then also, along with that, we know that we need to actually define for mandated reporters, what does general neglect mean? What does severe neglect mean? Severe neglect in the statute is not delineated. It's unclear. And we're thinking about, there's the child welfare has the structured decision-making tool, which helps them. They walk through the elements of these items of general neglect, of severe neglect, and they have definitions associated with them. So why can't we give that to mandate reporters, something similar? And then finally, we've recommended that there's a pilot to remove the liability that mandated reporters face in the statute if they use one of the decision-making tools. So if there's a county that has, like LA, that has a decision-making tool, and the mandated reporter shows that they've used that decision-making tool, even if they don't make a report, if they come out and say, we don't need to report this, the child is not facing a safety issue, and they don't report it, they would not be liable for, you know, those two liabilities of a fine or actual imprisonment. LA County just put through a proposed bill around this, asking to be able to pilot this in LA County. And unfortunately, that bill was just pulled. There was too much opposition from a variety of unions and groups. And so they decided it wasn't worth it to really water down the bill. So they just pulled the bill. But we would look to have that come up again next year. Next slide. These recommendations are around training. As many of you know, there's no statewide uniform training that mandated reporters are required to take. Many mandated reporters, as my colleagues mentioned, aren't even required to be trained. Some of your licenses might require that you're trained, your employer might require that you're trained, but statewide, only a few categories of mandated reporters are required to have training. This is a really significant piece of people's work. It is really hard, and it has such significant impacts on families and communities that it is our recommendation that everybody get trained, and that there is some uniform training that includes things that Clarence talked about, includes walking through the potential bias, includes, you know, opportunities of how do you talk to other people that you trust in your organization or other colleagues? How do you connect a family to resources, so that the training includes all those elements? So that work, we're working on that already to at the state level to create some type of training that has core content, including anti-bias, as well as working to encourage that there's better information coming out from the state, creating a mandated reporting page potentially on CDSS's website, California Department of Social Services, and then also having legislation that requires everyone, all mandate reporters, to be trained. Next slide, please. This slide is about that narrative change, right? We know that this work to change these systems, to change these punitive systems, is going to take a long time, and that work has to start with, us really looking inward. And how do we talk about families? And how do we look at families, particularly families that may not look like our own experiences, that are made up of different types of people? And so part of this, we've been going out and having these conversations and want to make sure that people know about these reform efforts, and to, think about other ways that we can get people to think differently. Next slide, please. So where are we? What have we been doing since the report was approved in September 2024? We have been moving forward, as I mentioned. You can go to the next slide. As I mentioned, we have stood up the MRAC to carry the work of the task force forward. We're super excited. There are 3 tri-chairs. 2 of them have lived experience. Juan Solis is the father engagement coordinator in San Bernardino County. And also we have people from different parts of the state, from the north, from San Bernardino, from down south in LA, and different types of professions. Janae Eustace, who's the president and CEO of the CAP Center in Sacramento, and Alicia Garupa, who's the chief of well-being in LA. Like the task force itself, the MRAC is diverse, and again has 50% of its members that have been impacted by mandated reporting or have advocated to change that system. With respect to data and accountability, we have started to work with the California Department of Social Services to collect that data on neglect that I talked about, to really drill down, to understand it. There have been some researchers who have looked in some counties further at that data around neglect and have identified that many of those general neglect cases are associated with pretty significant issues around domestic violence, mental health, and substance use. And so we need to think about that and ensure that communities get the resources in order to support families where that is part of their family experience. Policy, we're continuing. Part of this education is to make sure that we continue with the implementation of those changes under AB 2085 to the definition of general neglect. And then we're continuing to move forward bills. We're excited about this bill with Assemblymember Jackson that will require training, uniform training for mandated reporters throughout the state. And then on the community pathway, we've started to gather more and more information from those counties that have already set up systems, Humboldt, LA, San Diego, where they are, as part of their mandated reporting, they're giving mandated reporters the tool to access the supports for families. So in LA, you go through the decision tree, then you can click on, if you believe the family needs resources, you can right there, you click on online and it will give you a way to connect the family to resources. And there's also a tool that they're using where it's a closed loop referral. So you can learn whether there's an opening, whether there's eligibility for the family that you're working with, and then you learn whether they actually got the resources you referred them to. On training, I mentioned it, we're working with the Office of Child Abuse Prevention to create that more universal training. And then on the narrative shift, we continue to disseminate the information about the changes the task force has recommended, as well as about, what do we need to do to go forward. Next slide. What can you do after hearing this? How can you support this movement, these changes? You know, one, Clarence talked about all the work that you can do as a mandated reporter and how you can bring this into your own practice and into your organizations. You can make sure you read the report, share the report, let other people know that there are these efforts to reform the system. Let other people know that there are other ways to do this rather than report, report, report. Let people know that AB 2085 is really trying to disentangle neglect from poverty, and that the law changed to ensure that you're not considering a family's economic disadvantage when you're making that report of general neglect. And you can also participate in the Child Welfare Council meetings. They're open to the public. It's available on their website, and you have the opportunity to provide public comment at those meetings. So we're super grateful for all of you. I know you heard a lot from us. We talked quite a bit. We're really grateful for you being here, and for thinking about how can we all play a part and help to really change the system so that children and families do not have to experience the trauma that this system is currently bringing. We have time. We have 15 minutes for questions.
Which is good because there's some big questions in the Q&A. So I just wanted to say thank you so much to all of you for what you shared and all the advocacy work. And really, you know, I teach on ethics in our counseling program here, and so I'm often, you know, I teach the child abuse part, and we go through the state trainings right now, and really that there's such a push of, like, Clarence, what you had said, like, when in doubt, report. Like, that is such a common statement that's there. And I really like the idea of, like, when in doubt, question, or slow it down, or kind of think of that ladder. Really think through why you're making, because it's not, it can cause harm to report. And we're always trying to have that balance of doing that. With that, all of the training, everything that we say says reasonable suspicion, right? If we are not investigators, it's reasonable suspicion. That's the training I've always gotten. That's all of the things that we have say. And so one of our anonymous attendees said the same thing, right? They said, thank you so much for the advocacy work being done. I agree that the vast majority of reports do more harm than good. I do not want to make 90% of the reports that the law requires me to make, but I have been trained that I am reporting suspicion and that I am not meant to be investigating. I've often thought of conscientiously objecting from many reports I feel I'm required to make because of the harm I feel is done. With the use of decision-making trees, though, is it correct that our panelists are suggesting that the educator, medical provider, or clinician makes an evidence-based guess about the substantiation of their suspicion before reporting and only report what they believe is substantiated? Isn't this clearly against current law? Has any county successfully passed new law or policy that allows us to not just report on that reasonable suspicion?
I can address the last part, and then Clarence, I don't know, or Brianna, if you want to address maybe some of the first part. But big question, so bear with us here. But really important question. And so you are correct, the law is still reasonable suspicion. No county has addressed that, and it was actually brought up within our task force and very contentious. It was very hard to move people towards, you know, do we change that standard overall? And so no, the current changes are not asking you to determine whether something is likely to be substantiated. You are right, that is still the job of child welfare. But what current practice is asking you to do is to have enough understanding. If you have time, I know that it's not always, you know, reasonable. You don't always have time, but have enough understanding of what's really happening with that child and that family, so you can take that breath and think about, is this really a safety issue, right? So that general neglect, the standard has risen to substantial risk of harm. That is a much higher standard than it had been. So you're trying to think, is what I'm concerned about here, is that really going to lift this up to substantial risk of harm? And go through that process. And, should I talk to somebody about it? There's something that was happening at UCSF. They're calling it timeout. And before they were making a report, their doctors or their other medical professionals, they would get together and they would, bring together some disciplines, the social worker, the doctor, the nurse, whoever was involved, and ask some of the questions about the family. Like, what are the family's strengths? What are we really concerned about here? And also try to check for that bias. So that's really what we're asking. And when I talk to child welfare about what does it mean to investigate, what I am hearing is that you can ask questions, but no, you're not, we don't expect the mandated reporter. We don't want the mandated reporter to do what they do, which is go out to the house or to, start looking at the child's body for other signs of something that you're concerned about. That investigation is to be left to child welfare still. And on the pilot, LA, as I mentioned, was hoping to be able to pilot essentially this, using that tool that Clarence talked about, and then removing that liability piece to sort of test that reasonable suspicion, test that push to report. And unfortunately, there was too much opposition, and we learned a lot, and that happens a lot of times. Bills are pulled one year, you build your coalition the next year, and you try to move it forward the next year. Clarence, Brianna, do you have anything to add to that?
I can add something real quick. I think part of the challenge here is, and the reason why we, in our training and the section that Brianna presented, we wanted to really try and show exactly what's written in Canada is because to point out really that a lot of it is very vague. And I think that serves the purpose of making it so that you are unsure of whether or not you should report or not sometimes, right? And I think this element of like where there is potential repercussions for not reporting creates an environment in which you really do have to ask yourself, why am I making the report? And if you are coming to the realization that I'm making the report because I'm afraid of repercussions for me, then I think we're getting to a place where you likely are not making an informed report, and a report that is going to be supporting that family or that child that you are working with, right? And I think if that's the case, more harm is being done than good, which is why I think, and I saw in that question, I think towards the end, thinking about like, why is training important? Training is really valuable because you are engaged in these conversations. You are looking at what does the law say? What are the requirements of mandated reports? What is not written in law? And we need to continue having these trainings, continue updating, continue having these discussions, because only in having these discussions do these questions come in and do these conversations come up. And part of it is very similarly earlier where we don't want to be thinking or like making decisions in silos. We want to be making decisions in community, right? Where it's kind of like we are having a collective responsibility for this system that we are a part of, right? And I think also when we're thinking about the system itself, they are moving in this direction. So I think, and Brianna, maybe you can speak more to this, you can call like the hotline and ask for advice instead of reporting, right? And I think they can also give you some informed information with regard to things that you're thinking about, things that you're considering before making a report. And I think they're more than happy to do that because they're also suffering from this over-reporting. If we're over-reporting and there's lots of reports coming in, they don't have the capacity to be able to support all of those reports and make informed decisions when going out into the field either, right? So it's also in their best interest for you to be thinking before making a report. But yeah, I don't know, Brianna, if you want to add to that.
Yeah, I don't really have much to add, but you are right. If you are in doubt, like, oh, should I report this or not? You can call to consult. And then the hotline worker will try to walk you through it. But you can call to just to consult if need be.
And I would just like to reinforce that that is true, because sometimes you call to consult and they say, we don't do that. And you just need to hang up and call again and you'll get someone who's a little less burnout that day, and they will consult with you. So that's happened to my students a handful of times where I say, you can call the consult, and then you get that person who's like, no, you gonna file it or not? You're like, "Oh,
Mhm.
you need a Snickers bar, and then we're gonna, I know your job is very hard, but we're gonna come back." So
The
yeah.
same has happened to me.
Mhm.
And like you said, Tiffany, you can just call back. And yeah, yeah. And sometimes like there's been a time when I called to consult and I was like, well, should I report it or not? And they were like, well, that's up to you at this point. So and in
Yeah.
that time you can call back if you feel the need to.
For sure, for sure. With that, you mentioned the hotline number, the 800 number that you shared. Somebody asked, is that statewide, or is that just San Francisco County only?
The 800 number is for San Francisco only.
Okay.
But you can always Google the county that you're trying to call. The
Yeah.
form though is California. So the form is statewide, but the
Yeah.
number is for the different county. Or it's
Awesome.
for your county.
Awesome. Okay, I think we've got time for one more question. So there's several in here, but I am going to just bring up this one. So Casey asks, what's your sense of whether police are joining / being a part of the CPS process? In my experience in Daly City, is that police were often going out on calls instead of a social worker. Do you know if this is still happening or if changes are being made with this? When I would fax over my report, they would also send it to police, which would often be more traumatizing for clients.
That's interesting. I think it's county by county. If there's domestic and violence involved potentially, or any kind of violence amongst the adults involved, then it's certainly that usually goes to police. The obviously, or not obviously, but CANRA says, the statute says you can call the police department or you can call child welfare. And yes, they have an obligation to cross-report, which is really important because if police doesn't cross-report to child welfare, a lot of times that family can get lost in the system, and they might be traumatized by the police. Um, in San Francisco, we actually have the opposite issue that police aren't coming out on calls, and we have a children's advocacy center, so we try to coordinate so that actually a social worker does go, and sometimes that, if there is a need for police um, questioning or investigation, that it happens together, and also so that child or that family doesn't have to tell their story twice. So I think it really depends county by county. But the cross reporting, in my experience, has been really essential to have our system work appropriately. But I agree with you, having the police show up at a family's door is certainly traumatizing.
We do have like 1.5 minutes left, and somebody asked a clarifying question about one of your slides, so it might be helpful for them. But so someone said, Jenny spoke of a percentage of reports substantiated. I think you answered this a little bit, but it was the 1 in 9. And investigated 25% white, 50% Black and Native. And then Brianna spoke of reports being assessed as unfounded, inconclusive, and substantiated. I'm curious how these words all overlap. Are the words assessed and investigated the same in these two separate uses, or?
Brianna, do you want to answer that?
Yeah, and you probably gonna have to back me up, and that's fine. So when I spoke about unfounded, substantiated, and inconclusive, those are the reports from FCS. So after the hotline worker goes out and does whatever investigating that they, I'm sorry, not the hotline worker, the social worker, does whatever investigating that they need to do, that's what they're coming back with. Um, but I fully didn't answer your question because I don't, and Jenny's gonna, if you can, I don't know how they are used, or even if they are used interchangeably.
So I think Brianna was just going through, there are different dispositions for the cases. Some are evaluated out, might be there's not enough information, might be the child's over 18, might be all kinds of reasons for evaluating it. They just don't have any information in order to take any action. And then Brianna was going through the different pieces. I think the piece that you're saying that connects our two pieces of information is that substantiated piece. And that substantiated piece is when the case has been opened, been investigated, gone through child welfare. Child welfare has made a determination that there was some type of child abuse or neglect. happening. And so they've substantiated. They may still take a different action. Sometimes they remove the child. Sometimes they have a case that's court monitored. Sometimes it's not court monitored, but still the family has a case. But that substantiated rate is really low for all of that. For all those actions, that substantiated rate is only 1 in 9.
Those stats are just, wow. Yeah, thank you. So I'll be sitting with those. Thank you so much for all of this that you shared, all the decision-making trees. And as we put in the chat, the video will be up on YouTube soon. We'll post the PowerPoint or the slide deck on our website as well. So you'll have access to that. Thank you so much to our very knowledgeable and amazing presenters. Thanks for the advocacy and the work you're doing. We really appreciate you all, and hope everybody has a good rest of your day and then weekend.
Thank you all. Thank you all for your work.
Yeah,
Bye.
take care. Bye all.